So in 1998, Abdullah Yerodin Mbasi gives a speech wherein he allegedly incited racial hatred against Tutsis. Now, while this was widely considered to be a dick move, it was also under a 1993 law illegal in Belgium. And so, on April 11, 2000, based on that law, a judge in Brussels issues the arrest warrant against Yerodin. This is the arrest warrant of April 11, 2000. The only problem was, by the time that arrest warrant had been issued, Yerodin had become the Minister of Foreign Affairs of the Democratic Republic of the Congo. Based on the idea that issuing the arrest warrant violated the diplomatic immunity of Yerodin, Congo sues Belgium in the International Court of Justice. So, jurisdiction. In 1958, Belgium had agreed to accept the jurisdiction of the ICJ, and the Congo had done the same in 1989, so there was no issue there. But there was a bigger issue about whether or not there was an actual legal dispute. This was an issue because in April of 2001, because of a change in government, Yerodin had stopped being the Minister of Foreign Affairs and had become the Minister of Education in the Congo, which meant that he no longer had the immunities associated with that office. But the Congo said that even though he had stopped being the foreign minister, there still was a legal defect that hadn't been fixed. And so, although it wasn't unanimous, it was controversial, the court still ruled 15-1 that the court had jurisdiction because there was in fact a legal dispute. And so the meat of the issue was whether or not a foreign minister has immunity against prosecution by a foreign state. The answer is yes, and it comes mostly from parem panem non habet imperium, which basically means that there is no sovereignty amongst equals. The issue isn't an issue with the right of the individual foreign minister, but it's the problem that the foreign minister, along with other high-ranking officials, like the head of state and head of government, have the ability and have the right in law to make decisions that bind the state that they are associated with. So, for example, the president of the US has the right to make decisions that then binds the US. Because states are not people or objects, they're intangible ideas, they have to act through their high-ranking officials, and so by arresting or even by issuing an arrest warrant against those high-ranking officials, you are limiting the state's ability to make those decisions and to carry out its policies, and that is a violation of the state's rights. Now, there still was some controversy because the arrest warrant specified that Yerodin would not be arrested if he were in Belgium on official business. And so there were some judges that said that the only way that this would really affect a foreign minister was if he was a little bitch, but in the end, they still ruled 13-3 that there was a violation of the rights of the Congo by the issuance of the arrest warrant. And so even though that by the time the judgment was decided, Yerodin had stopped being a minister altogether, he was a civilian by then, the ICJ still ruled that by issuing the arrest warrant, the judge in Brussels had violated the immunity of the Congo, and that Belgium had to rescind the arrest warrant. The main takeaway here is that high-ranking officials, at least, possibly not limited to, but at least the head of government, head of state, and foreign minister always have immunity regardless of what they do or where they are when they do it. And so long as that individual remains in that office, they cannot be arrested, and foreign states cannot issue arrest warrants against people who hold those offices. Now, the rules are different when it comes to the International Criminal Court, but when it comes down to national jurisdiction and national courts, at least those three offices, and possibly others, are always immune.